Okay. I'm ready. Hello, everyone. My name is Sean Russell, and I'm an housing consumer staff attorney here at MVLS. And I just want to say thank you for coming to the webinar on consumer defenses for district court. I have the honor of introducing today's speaker. Our speaker today is a partner at SVO, Santoni, Vocci Ortega, LLC, where she advocates for consumers and tenants taking on unfair debt collection and housing issues. She's been fighting for the rights of everyday people for over a decade. Please welcome Chelsea Ortega.
Thanks, Sean. So welcome everyone to this webinar on common defenses in district court. As Sean mentioned, I've been representing consumers sued by debt collectors for over 10 years. My firm primarily represents tenants living in uninhabitable conditions, facing illegal lockouts, debt collection issues, and a variety of other things. We also represent consumers with errors on their credit reports. I'm going to start the PowerPoint. While I do that, I'll just give a preview of what we are going to be discussing today. So I'm going to first start by going over the district court process, what to expect, as well as then we're going to talk about defenses across all case types. And then finally, some specific case types and what defenses you can raise in those types of cases. So Maryland has a procedure that's a little different from other states, and that's affidavit judgment. And this is typically most cases that I've seen that are debt collection cases are filed under affidavit. And that means that the plaintiff can file the demand for judgment at the time that the complaint is filed. There is supposed to be an affidavit showing that the plaintiff is entitled to judgment that's provided as well. And there's a section actually in the complaint that we're going to look at that discusses that. If the defendant doesn't file a defense or show up, then the court will simply review the documents and enter judgment if the court finds that there is enough there to enter judgment for the plaintiff. The court could deny affidavit judgment if there's documents that are missing, if the affidavit is incomplete, or, for example, if the military service affidavit is incomplete. But it's very unusual in that the plaintiff does not have to actually appear at court for judgment for their trial if the defendant does not show up and if the documents are sufficient in the court's eyes to file judgment, to enter judgment. In Baltimore City, it's a little bit different in that the court will actually schedule an affidavit judgment hearing when the summons is generated, and that gives the litigants a chance to show up at the hearing to enter a defense at that time. But all of the jurisdictions are different. So if you do have a case that's filed under affidavit and you're going to be entering a defense, we're going to talk about what to do, but you should also check in with the clerk's office and with people who practice there and find out what is the process in that jurisdiction. So this is an older version, but I think it's pretty much the same now, of a district court complaint. You'll see up at the top, I've circled, it says complaint/application and affidavit in support of judgment. The district court does require all complaints. This is the form that everyone has to use when filing a complaint. You'll see sometimes the plaintiff will add a line in the here in this portion here, the particulars of the case, see attached, where the plaintiff will provide more information about the claim, but this is the form that's required to be used by the clerk's office. And then at the bottom here is the application and affidavit in support of judgment. And this is what is filled out if the plaintiff wants to seek affidavit judgment. So in order to avoid affidavit judgment, the defendant needs to fill out a notice of intention to defend. And we're going to talk about other things that can be filed, but this is the typical response that you'll see in a district court case. And the notice of intention to defend basically says that the person has a defense and intends to appear at trial to assert to carry out that defense. And so once the notice of intention to defend is filed, the defendant doesn't have to show up at any hearings. If there is a separate hearing that's scheduled in a jurisdiction like Baltimore City, the court will go ahead and set it in for a merits trial at that point. The rules do say that the notice of intention to defend is supposed to be filed within 15 days of service of the complaint. But again, the jurisdictions differ on how they treat late notices or when they have to be filed. But generally, best practice is get the notice of intention to defend in within that time period, once the defendant is served with the complaint. There is a separate rule that addresses the notice of intention to defend at the affidavit judgment hearing, section 3, well, it's section E of Maryland Rule 3307, which deals generally with notice of intention to defend. And the court has to then be satisfied that the defendant has a meritorious defense. So you do want to make sure, if you're going to be asserting a defense, that you provide details as to what that defense is. The defendant disputes that they owe the amount of the debt because, they don't know, it's not their debt, or the amount is incorrect, or the plaintiff failed to follow XYZ statute in pursuit of the debt. So you just don't want to put defendant disputes they owe the debt. There should be some detail there so that the court can assess whether it's a meritorious defense. Again, this process is going to differ based on jurisdiction. So make sure you check your clerk's office, check with the clerk's office to see how they handle things and what you should do. And this is a summons, just to kind of get an idea. And this one's issued by Baltimore City again, just because that's where I've typically practiced and represented clients at the affidavit judgment hearing, and the different clinics that the legal services providers provide, including MVLS. So up at the top, it'll give you the trial date, and this one has been filled out as far as the service, but it does provide the notice of intention to defend right on the writ of summons so that the defendant can fill it out and send it back to the court. So if you are appearing at an actual affidavit judgment hearing in Baltimore City, typically only the defendant appears. There's an opportunity to enter the notice of intention to defend, to speak to the judge, but if the defendant does not appear, then affidavit judgment is entered. Here, I've outlined assigned consumer debt is a little bit different than other types of debt. The law changed a couple years ago to make it to make sure that the assignment companies were following certain rules. And so there's an additional portion of the complaint that they have to fill out if it's assigned. So assigned means simply what you typically will see is a debt buyer. There's a bunch of different companies out there that buy debt. So let's say a credit card company charges off the debt, and then a big debt buying company will buy a portfolio of debt that includes that credit card company's debts. So, it might be ABC debt buying, I'm just making it up, buys credit card A's debt. And so then ABC debt buying sues consumer who has no idea who ABC debt buyer is. But this is a practice that we allow in this country, and we regularly see it in district court where these debt buying companies have been assigned debt and are pursuing the debt. If you do notice that any of these, so this is the portion of the complaint that the debt buyer has to fill out, section 2 through 8. And if you do see that or any of these areas are not filled out properly, not filled out at all, not filled out properly, then that is something you want to raise in your notice of intention to defend, that there's errors in the assignment application. So just generally, if you are attending specifically some type of clinic that's meeting with people at the stage where affidavit judgment is being considered, You want to, obviously introduce yourself as if you're volunteering that day, a volunteer attorney with such and such organization. Ask them questions about, what contracts they entered into and what payments have been made. Explain the process of affidavit judgment. A lot of times when I meet with people, they are very confused about the process. I've had people ask, are they going to go to jail? They were afraid to miss court because they were afraid they were going to go to jail. They don't understand that it's not the actual marriage trial. They want to talk to someone from the plaintiff's side there, and you have to explain they're not there typically. So you want to explain give them advice about what's going to happen, what to expect, what's going on, because it is a unusual process. And then explain the consequences of a judgment. That can mean wage garnishment, attaching property, bank accounts, and that how long a judgment lasts, and the fact that it can be renewed, so that they clearly understand what happens if they aren't going to file a notice of intention to defend or any response. Then judgment could be entered and what that would look like for them and the consequences of a judgment. So now moving to the portion of the webinar discussing common defenses. And this is where I'm going to talk about just generally every kind of case type that you may see. The first one is going to be service. So you want to make sure that the defendant was actually served with the complaint the way that Maryland rules require. Actually personal service on the person, which is a lot of times what we see in these cases. So a process server is going to their house, they're knocking on their door. The actual defendant is either answering the door and accepting those materials, or someone that lives in the household that's of suitable age is accepting those and has affirmatively stated that the defendant actually resides at the property. So sometimes we have people say, well, my 17-year-old accepted the documents. There is nothing in the law that says that they have to be an adult. It just says someone of suitable age. Courts would probably find that a 17-year-old is of suitable age to accept the documents. I've not challenged that specifically or heard, but there is no actual age requirement. So that's something to be aware of. But if the defendant says, I just found a packet of documents on my porch, or I never actually was served at all, I just got a notice in the mail to show up here today from the court, then you want to dive into that a little bit and figure out what happened. And one way you can do so is check the affidavit of service with the court. Who does the process server say that they served? Does it say that they served the actual person? If so, does it match the description of the person in front of you? I had a case where they said they served the defendant, my client, that he was 5'11", and had hair, and my client was 6'7" and bald, and the judge took one look at him and said, obviously you do not match description, and vacated service. So check the description there, talk to the client, find out whether they actually received the paperwork or not. If you are going to prove that the person was not served and they say, no, I haven't lived at that address, or I don't currently live at that address, I wasn't at the address at the time that they say I was there, what kind of documents can you get from the client to prove that they weren't living there at the time? So you want to try to get a lease, a driver's license showing a change of address or a different address at the time. Anything that you can show the court that supports the client's assertion that they were not living at the address at the time. Lack of service is waived if you do not raise it preliminarily. So if you file a notice of intention to defend, you cannot then later bring up lack of service. So you want to make sure that is the first thing that you raise with the court so that you're not waiving that right. And sometimes you get pushback from judges on the lack of service, and I just try to emphasize that this is a fundamental due process right. I've included a case there that talks about that. Just because the person has shown up at court today doesn't mean that they have had a chance to properly prepare a defense, because they don't have a copy of the complaint. And so, this is something that has to be done by the plaintiff to ensure that they are entitled to a judgment. They have to properly serve. the defendant. The next thing you want to look at as to whether or not there's a defense is whether or not the plaintiff has a right to bring the action. The first step is going to be looking at the State Department of Assessments and Taxation website. So Google SDAT, business standing, and make sure that whoever is listed as the plaintiff on the complaint, whatever that might be, that entity is in good standing. If it's an LLC, for an example, and it has been forfeited, then the case law supports the fact that it is not able to bring an action. So you can move to dismiss the action for lack of standing because the entity is forfeited. The other thing to check is it the correct plaintiff? Does it match the plaintiff's name, match whatever is on the contract? Because sometimes you'll find they don't. So make sure that you're looking at that and move to dismiss pursuant to Maryland Rule 3201 at that point. The next thing that I typically look at is then who's bringing the action for the plaintiff. So if it's a large claim and it's a company, it has to be represented by an attorney. But that's not the end of it. You want to then go on to mdcourts.gov, check to make sure that the attorney is in good standing, is licensed in Maryland, and also able to bring a case here in district court. Now, even if it's a small claim, there are instances when a company has to be represented. A company has to be represented by an attorney, or if not an attorney, then there's a specific statute that addresses that representation. And so I've cited it here. It's the Business and Occupations and Professions statute. And it says that there has to be either an affidavit from an officer of the corporation or the I think it's actually not an affidavit, it's a power of attorney. So there has to be a power of attorney provided that says that this employee has the right to appear on behalf of a corporation, partnership, limited liability company, or business. So what you'll typically find, what it'll look like in practice is ABC Company, LLC, and then it'll just be signed by Jane Smith. And you say, well, there's no the number, the AIS number that designates the person as an attorney behind the name. And you go on mdcourts.gov, you've looked up Jane Smith, she's not there. And at that point, you would check to see if the complaint, if there's a power of attorney attached to the complaint that says that Jane Smith is able to act on behalf of this company. If it's not there, then you ask the court to dismiss because they haven't met the requirements. And so here's the 10206 power of attorney, what it has to set forth. It has to be certified, has to certify that the employee is an authorized agent and may bind the organization on matters pending before the court. And you know, I've seen quite a bit of these over the years, and you want to make sure, like, does this person actually even work for this company? Because even if there is a power of attorney, which a lot of times there's not, there might be some indication, a LinkedIn thing that you find for this individual that says they work for a different company. Their email address might be something different that's on the complaint. So, you know, or the documents may even support that this person works for a completely different company. So don't just take it at face value, really scrutinize the documents, the power of attorney, the complaint to figure out whether or not it's accurate and truthful. The next big defense that you want to check and be aware of is statute of limitations. Most causes of actions, it's going to be 3 years. There are exceptions, however, for car cases, repossession cases, the statute of limitations is 4 years. Any contracts that are signed under seal, if they're a specialty contract, then those are also going to have extended statute of limitations beyond 3 years. However, those are prohibited, at least as far as in residential landlord-tenant leases. Even if the lease says it's signed under seal and the landlord has, more than 3 years to file suit, the appellate court has said that that is void, it's prohibited, it's not enforceable. So in landlord-tenant cases, they have 3 years to bring a cause of action. Now, when does that 3 years start? So, look at when the consumer made a payment, last made a payment, or last made a purchase. And then it's the following month is they're technically in default typically. And so that's what you want to look at, find on a ledger or a payment history, find out when those payments were made. And if that's not attached, then find out from your client, hey, when did you last make a payment? When did you last use your credit card to determine? And then hopefully they have some documents to support that if it was more than 3 years ago. Are the charges more than 3 years old, right? So, and it should be all the charges, not just so what sometimes you'll see is they're claiming, let's say $5,000, and some of that $5,000 occurred more than 3 years ago. Well, then that cannot be included in the calculation. It has to, all of the charges have to be within whatever the statute of limitations is. Sometimes this can be tricky. You'll have clients who are like, I haven't lived there for 5 years, 6 years. There's no way I could still owe this. It has to be too old. Statute of limitations have expired if they've done any Googling. But the date that the court looks at is the date that the lawsuit was filed, not the date of service, not the date that the client comes to trial. So what you'll sometimes see is a lawsuit was filed, but the plaintiff couldn't find the defendant. And that means that they were trying to serve them at different addresses. It took a long time. Maybe it took a couple years. And now that they finally have achieved service, they're ready to prosecute the case. And, unfortunately, a lot of time may have passed. And that means that a lot of times the defendant no longer has documents or things that'll help with their defense. Venue is also a defense, although it may not be a complete defense to the action, but it at least serves as a defense for being hauled into a court where you say that there may not be any venue. So for venue questions, it's whether or not the consumer lives or works in the venue we're being sued. Another is whether the contract was signed in the venue we're being sued. So if they signed the contract in Baltimore County, they've always lived in Baltimore County, the creditor cannot sue them in Baltimore City. At that point, you would move to dismiss or transfer for improper venue. So that's Maryland Rule 3326. Typically, the court will transfer, they won't dismiss, but it is in the rule and you can argue it. And I suggest you do to see if hopefully you can get the matter just dismissed because the plaintiff filed in the wrong place. It is also a violation of federal and state debt collection laws to file in the wrong venue. The Federal Fair Debt Collection Practices Act is there. That's 15 U.S. Code 1692. And I put I there. That's that specific section of the FDCPA. And then the Maryland Consumer Debt Collection Act also incorporates the FDCPA, the Federal Debt Collection Statute. And so a violation of the FDCPA is a violation of the Maryland Consumer Debt Collection Act. And I've provided that site there as well. So now moving to specific case types and defenses that you may have for specific case types and what to look out for. So the first is credit card cases. I would say this is a large portion of the debt collection cases that we see that are filed in district court, either by the original creditor, so, Visa itself, or by a debt buyer who has bought the debt. One of the defenses that you could have, other than all the ones that I've just gone over, specific to credit card cases, is identity theft. And we've really seen a rise of this over recent years. If the person comes and says, I never opened this account, I don't know what any of these charges are, I know my credit was stolen because I've gotten other bills that aren't mine, that could indicate that there was identity theft. At that point, you would want to advise the person to file an affidavit with the Federal Trade Commission, the FTC, because they have a specific affidavit the person can fill out and then use that affidavit in different ways. They can also file a police report, which I would advise them to do, because that helps again with get a defense in court and other things as well. And then what you want to look at are for the court to prove that this isn't the person's debt is look at their address on the statements. I did have one case where the original creditor admitted that the statements that were attached to the complaint, the bank statements, they auto-generated the address after, so for court purposes. So they didn't have the original statements to show that it wasn't actually sent to my client or in his name. It was actually sent to his someone else with a different address. But they generated the statement for court that populated his address. So look at that as far as, what address were they sending statements to, and then the charges. Sometimes you'll see charges for things in a completely different state. We had a case where they were using the card in Washington State to buy gift cards at Walgreens. And our client said, I've never been to Washington State. And that is also indicative of fraud or theft when the card is used to purchase gift cards, untraceable things like that. So look at the charges that are attached to the complaint to see whether or not they're indicative of fraud or identity theft, and talk to your client about, if you can prove that they've never been there or they weren't there on that date that they were, that the card was allegedly used. Sometimes we've been able to use parking receipts to show, no, I was in Baltimore City that day, or easy pass statements to show that they were in a completely different state than where it was allegedly used. Moving next to another common case type that we see in district court, and that's landlord-tenant cases. There are a lot of defenses now to landlord-tenant cases because the law is continuously changing. There's new cases coming out fairly often on landlord-tenant subject matter, and so there are a lot of different things that are available to you. The first is whether or not is the property required to be licensed, and if so, was it? Many jurisdictions required landlords or properties to be licensed before the owner can rent out the property. If you're in a jurisdiction like that, and if the property is not licensed, then the landlord and the property manager, whoever, nobody can assert a right to collect rent during the whole time that it was unlicensed. So even if the landlord becomes licensed later, they can't go back and say, well, now I'm licensed, so I want to claim all the years I wasn't licensed. It doesn't work that way. There's case law to support that. And it's really jurisdiction specific. Not only you have to look at the county that you're in, but some jurisdictions you have to look at the city that you're in because they have their own licensing scheme. So if you have questions about that, you can feel free to reach out to my firm or others and advocates to figure the licensing issue out. The other requirement is whether or not the property was required to be registered with the Maryland Department of Environment because of lead paint. If the property was built before a certain year, then and the owner wants to rent out the property as a rental property, then it has to be registered. And just like for licensing, generally licensing, the lead registration piece, without that, the landlord should not be collecting rent, should not be renting it out, and should not have a right to then file for back rent after the person has moved out. Habitability issues are another defense when a landlord is seeking money for rent or damages after the tenant has moved out, or even if the tenant is still there. I've seen those as well. So if the issue was one that violates the local housing code or the warranty of habitability, which is now a state remedy and state, we have that as a state right across the state, then that could be a defense to the rent. So examples include pests, rodents, roaches, bed bugs, sewage backup, lack of heat, Lack of AC is a little bit trickier. You have to look at your local jurisdiction. And I would say for all these issues, look at whether or not there is a local code, housing code, and what it says. If it has an itemized list, or if it's something that you have to kind of argue is a habitability issue. It does not include things like the cabinets are on crooked, um, uh, the sink and the vanity was outdated. Obviously, nothing cosmetic, has to be a habitability issue. Rental assistance is another area where there may be a defense. So this would be if the tenant was living in the property, maybe fell behind on their rent and sought rental assistance from some kind of government agency or entity that was providing rental assistance. I have seen where a landlord receives rental assistance on behalf of the tenant and the tenant moves out, and then the landlord sues the tenant for the period of time when they receive rental assistance. And almost always there's some kind of agreement between the rental assistance entity and the landlord that says clearly what months are being covered. It indicates what amounts are being covered. And usually there's also some kind of guarantee that the landlord will waive certain fees as to the collection of rent, will not seek eviction, different things like that. So if the tenant is telling you, I got rental assistance, hopefully they have a copy of the agreement. If not, figure out which jurisdiction they're in. You can figure out which entity usually is providing the rental assistance at that point. Get a copy of the rental assistance agreement to figure out exactly what was covered and whether or not the landlord is just trying to seek the money again for whatever reason. But that would clearly be a defense. The landlord can't get paid twice for the same months in rent. Looking at the ledger, look and see whether or not the charges appear reasonable. So hopefully the landlord has attached a copy of the tenant ledger, which is a list of all of the charges and payments that the tenant has, and see, are they claiming $15,000 in property damages because they renovated the entire kitchen? Well, your tenant is only responsible for reasonable wear and tear, not for an entire kitchen renovation. So those are things that you need to look at. And some of it comes with practice, looking at a lot of these, but some of it's just kind of common sense. Reasonable wear and tear does not, is little things they can have little dings and things in the wall. It's, did they knock down a whole wall or set the place on fire? Obviously that's different. So there's a range there, but and there is no definition of reasonable wear and tear. Unfortunately, in Maryland, there is a Massachusetts case that just recently came out that said that the landlord can only charge for reasonable wear and tear, and discusses the fact that they can't have charges in the lease and just charge for those items without determining whether or not those things were reasonable wear and tear or not. So there was just an automatic cleaning fee, those types of things. They may not be legitimate or recoverable in Maryland. We'll see. Is there documentation to support the claim for damages? Have they attached copies of pictures of the property? Does it look like, they punched a hole in the wall? Does it look like the carpet is significantly stained where it had to be replaced? Those sorts of things. Look at the pictures. Sometimes I've seen in the pictures, it's helpful for our clients. One was there were clearly rodent holes in the walls, or there are rodent feces on the stove. Then that helps you to establish that there was a habitability problem. And so if there are pictures, look at those, see if they help your client and whether you can use those in support of their case. Another area is whether or not the lease even allows for the fees or the charges. So unless the lease says you can charge this fee, whatever it may be, they can't charge it unless state law allows. So look through the lease and make sure that every single charge that they're claiming is provided, is allowed. And even if the lease does allow, though, check state law on certain things like late fees. There's caps, application fees, there's caps. We could do a whole seminar on all the different fees and caps and charges. We don't have time for that today, but like I said, reach out to me, my firm, reach out to advocates. And if you have a case that you're unsure of, I'm happy to talk to anybody at any time. One final note on landlord tenant cases before we move on is prejudgment interest. So that should start from the date the list of charges are sent to the tenant. Sometimes you'll see it's from the date of move out or even earlier, and it has to be the date that the tenant is aware of what the amount is being claimed. So the landlords typically within 45 days of the tenant moving out will send a list of the charges if they want to keep the security deposit, which again is another lesson for a different day. But that's where you'll see the list of charges being sent typically is within that 40-day period. And that's when the prejudgment interest calculation starts. Just briefly, I'm going to touch on bail bond cases. Thankfully, we don't see them too much anymore because cash bail the requirements have changed in Maryland over the years. But if you do see one of these, the bail bond company is required to be licensed by the Maryland Insurance Administration. You can look that up. I've provided the link here. If you Google it, you can find it pretty readily. They can't seek prejudgment interest, and bail bond premiums are limited to 10% of the total bail amount. So you want to check those things. And then there is a requirement about bail bond installment agreements. There's a law that specifically addresses what they have to contain. So they have to include the total amount of the premium owed, amount of any down payment, the balance amount owed, amount and due date of each installment payment, the total number of installment payments, and bail bond installment agreements cannot include a confessed judgment clause. Confessed judgment clause means that the person confesses to judgment, so they don't have the ability to show up in court and contest the debt. These are also prohibited in consumer contracts generally as well. All right, so now moving to automobile repossession cases. So Maryland is not like other states, and other states just have the UCC as it applies to car financing agreements. We have lots of different laws, which makes it fun and interesting trying to figure out which law applies and what the law is as it pertains to your contract. So there are, though, lots of possible defenses available to you if you have a client who comes to you and says, my car was repossessed and now I'm being sued. But the first thing you have to do is figure out what law applies. So you want to look at the contract, and it should have a section that says what law governs or applicable law. And we're going to look at that in a second. But if it was signed in Maryland, typically you're going to find CLEC, and that's credit grantor closed-in credit provisions. And that's found at the commercial law article 12-1001 et sec. We're going to talk about CLEC in a minute. If the contract is a retail installment sales contract, and that's what it'll say at the top, that's what most car contracts are, but the contract does not elect CLEC, meaning it doesn't say that CLEC applies, then RISA applies, the Retail Installment Sales Act, and I've included the site there. If the contract is not signed in Maryland, then it's probably UCC. Or sometimes I have seen where it's UCC in Maryland, but typically it's going to be CLEC. That's going to be what you normally find. And that's because they can charge a higher interest rate if they elect CLEC, the finance company. So here's a retail installment sales contract for the purchase of a vehicle, sample one. And you'll see here I've circled under paragraph 7, applicable law. This contract shall be subject to the credit grantor closed-in credit provision, subtitle 10 of Title 12 of the Commercial Law Article of the Maryland Code. So that tells you that the law that applies to the contract is CLEC. Now you might say, man, Chelsea, you're making a lot of big deal about this. What does it matter? It matters because the notices that have to be sent and some of the procedures that apply when the car is repossessed and after the car is repossessed is vastly different for the different statutes. And actually, if they follow a different law, they violate the other one. So it's important. If CLEC applies, then the post-repossession notices after 5 days after repossession have to be sent out by registered or certified mail, and they have to provide the following information: the right of the car owner to redeem the car and the amount required to do so. It also has to include a sentence about the rights of the borrower to resale and their liability for a deficiency. A deficiency is what they call when the creditor files the lawsuit after the, well, really a deficiency could be even before the lawsuit's filed. Anything that's owed over and above when the car is sold at a private sale or a public sale. And then it also has to include the exact location where the property is stored and the address where any payment is to be made. So it has to include those things. The vehicle must be sold after repossession at either a private sale or a public auction. And at least 10 days before the sale, the owner must be notified of the time and the place of sale. There's different requirements if it's a private sale versus a public sale. If it's a private sale, there's all these different requirements. I'm not going to go through each one, but basically there has to be a notice that's sent out afterwards that includes all of this information. Sometimes they get it wrong. They don't include like the number of bids sought and received at a private sale. The statement at the bottom about, the statement of the condition of the goods. So you really want to look at the notices and look at the statute at the same time, because you're not going to remember all these different things. And I've cited it down there, and just go through and check off like, okay, did they say this, this, and this? If it's a public sale and if the loan was in excess of $2,000 at the time the loan was made, the notice has to show the distribution of the proceeds. So after the car is sold at auction, a public auction, the creditor has to send a notice to the car owner that says, what was the actual and reasonable cost of the sale? What was the actual and reasonable cost of retaking and storing the property? And what was the unpaid balance owed at the time? Under the agreement at the time the property was repossessed, not sold, but repossessed. If the creditor does not comply with all of these notice provisions, they're not entitled to a deficiency judgment. So that's why it's really important to look at all the notices, make sure the information is correct, and also that they didn't apply the proceeds of the sale to something that's not in this list, because it's an itemized list that says what they can apply the distribution of the proceeds to. So if you see something else, administrative fees, key fees, something that you can't even tell what it is. If it's not a cost of selling the car, retaking or storing the car, then they probably can't apply the proceeds of the sale to that. And as a result, then you may have a defense to the judgment. All of the issues with the sale also have to be reasonable. So, if you see something like a Mercedes was sold for $500 and at auction it was brand new at the time, your client says there's nothing wrong with it, I bought it a month before, brand new, then you might want to question whether or not the sale was reasonable, because they have to follow commercially reasonable procedures in selling all aspects of the sale of the car. So what if CLEC doesn't apply? What if the Retail Installment Sales Act applies? Well, then the notices are different. Within 5 days, similar things have to go out. But the vehicle also has to be stored for 15 days in the county where the goods were sold or were repossessed. So that's different. That's not in CLEC. That's a different requirement that RISA allows for, or requires, that they can't tow the car 100 miles away, which we see a lot. They have to store the car there for at least 15 days so that the person can get their things out. The possessions that are in the car belong to the person, not to the finance company. They are entitled to their possessions. There should not be a fee associated with that. They should be able to get their tags, no fee for the tags. And that is something that you'll commonly see, well, occasionally you'll see, is whoever's holding the car, the tow company, will charge for those items, and that's not permitted. There's a whole bunch of things in the sale process in RISA as well, when you have to send notice, and what the notice has to say. But again, if they mess up the notices, then the creditor is not entitled to a deficiency judgment. So the UCC notices, you have to provide some different information in post repossession, a description of the consumer and the secured party, the vehicle, how you intend to sell it, time and place of sale, and where the location of the vehicle is, as well as some other things, telephone number to find out amount to redeem the collateral. So some different things that are in those notices than in the other ones. I would say if you have a repossession case, again, if you're not sure, reach out to me. I'm happy to talk through any of those fact patterns with someone because they can be a little bit complicated. But the statute is clear on what can be charged, what the notices have to say, how long they have to store the property, how long the consumer can redeem the property before sale. So feel free to, reach out, but also look at the statute and just go through and make sure, check those boxes that the finance company did everything that they were required to do. Let's say you have a client and maybe they have some defenses, maybe they don't have defenses, but they're interested in trying to resolve the case without going to trial. So I just wanted to include, one slide on this issue because often people don't want to go to trial. They want to try to resolve it. You'll have some people who say, I acknowledge I owe the money. I want to pay the money. And so it's your job to try to facilitate that if that's what the client wants. You want to, contact the plaintiff's attorney if they have one, see if you can get a hold of that person, which can be difficult sometimes if it's a debt buyer. It's kind of difficult to get them, but I like to try to, whoever signed the complaint, I'll go on to mdcourts.gov and look them up and try to call that phone number that's listed there rather than the general number, if you can get that instead, because sometimes it can be difficult to even get a hold of them. If the certain types of debt, like credit card debt or debt buyers, will actually dismiss the case if the defendant receives public benefits. If the defendant is what we call judgment proof, meaning they don't have any assets that can be attached, they don't have any income, all of their income is protected income because it's Social Security disability or some other protected area, then ask the plaintiff if they'll dismiss the case. And the reason why sometimes they will do that is because it's not going to be worth their time to chase this defendant when there's no possible avenue for recovery, or at least anytime soon, no possible avenue. Sometimes what they'll do is have your client sign an affidavit to that effect saying, they don't own their home, they receive these public benefits. Sometimes they'll ask for copies of the documents showing that they receive, food stamps or things like that, SNAP benefits. And, I redact it and send that over to them. If they either won't dismiss if there's public benefits or the defendant doesn't receive public benefits, try to negotiate a lower total principal if you can, and that's just kind of up to you as far and up to your client, what can they afford? A lot of times these creditors will agree to payment arrangements. And so you want to talk to your client about what they can afford, how much each month, and discuss what happens if they miss a payment, which would mean typically that a judgment is entered for the total amount or whatever amount you agree on minus whatever payments are made. I included this note about don't give out employment information. Sometimes they'll ask for their employer. I don't think that's necessary for negotiating a settlement. If the person agrees to pay the money, they agree to pay the money, and you want them to sign a Rule 3506B dismissal, which says they've agreed to pay the money. And if they don't, then a judgment's entered. So I try not to give that to the creditor when I can, because I don't think, it's not required under the rules certainly to settle. And I don't think that they necessarily need that information. And so these are just some of the tips that I've got today. You also, if you can, get a settlement that's going to help your client avoid a judgment so that they're not facing those wage garnishments and bank account attachments. and things like that. Because the other thing that we didn't talk about, but the other potential, I guess, consequence is it can, affect their credit and their ability to get credit. So that's all I have. I have my email is there, my phone number is there. Like I said, please feel free to reach out if you have any questions at all. I'm happy to share notices of intention to defend, sample documents, discovery, whatever you're looking for. If I don't have it, I'll help you to draft it, get it for you. I'm happy to help anyone who wants to pursue this area of law. It's very important for everyone to have representation, even if they can't afford it, which is why I'm so passionate about the work that MVLS does and all the other organizations that help low-income Marylanders make sure that they have access to justice. So thank you very much. I hope that you found today's presentation helpful. Sean, are there any questions?
Thank you so much, Chelsea. I'm not hearing any questions or seeing any questions. So I just want to say thank you again for giving this training. It's very helpful. I learned a lot of useful tips. And this training will be available on MVLS's YouTube page. All right. Thank you again. Have a good one.
Thank you, you as well.